The Supreme Court has just stepped directly into a massive constitutional clash that could completely upend how the criminal justice system actually operates in some states. If you think that your right to a fair trial is completely safe under the Bill of Rights, you actually need to watch out, because the Supreme Court has recently granted review to a case that exposes how some governments in some states have been shortchanging your fundamental constitutional protections for over 50 years. This summer, the Supreme Court agreed to take up a very fast-moving challenge known as Keon versus the state of Florida. Now, on paper, this case started as a local dispute involving a state licensing issue, but now it has become a question about what the founders of our country actually meant when they talked about your right to a jury trial. Currently, there are 6 different states that have been actively bypassing the traditional 12-person jury requirement, convicting individuals using a shrunken 6-person jury instead of the 12. The current conservative majority of the Supreme Court just signaled that they are ready to completely tear down that type of loophole, and we have some major procedural updates in this case, and it shows that the clock is now officially ticking on this case. The opening briefs are currently due next month, really in just a week, and both parties are actively targeting live oral arguments in front of the Supreme Court by this December. So before the end of this year, this critical constitutional clash will take place in front of the Supreme Court. So we need to break down what is happening in this critical case and why this timeline actually just accelerated. Now, before we talk about what is going on in this constitutional case in front of the Supreme Court, if you like this type of video and you want to get these videos going forward, make sure you subscribe to the channel and also turn on all notifications to ensure you never miss these videos when I release them. Now, to understand why this case sent shockwaves through the legal community, we have to look at kind of the bizarre facts that brought this case all the way up in front of the Supreme Court. Now, the petitioner here is a Florida resident named Mr. Keon. He was charged by state prosecutors with multiple felony counts, essentially of practicing chiropractic medicine without a license. At the time, it was a suspended license. Now, under normal circumstances in federal courts, if you face serious prison time, you are guaranteed a traditional and robust 12-person jury to stand between you and the power of the state. But Florida, along with 5 other states, including Arizona, Connecticut, Indiana, Massachusetts, and Utah, have exceptions to that rule. For non-capital offenses, they shrink your constitutional shield and your right to a jury from 12 to 6 people. Mr. Keon was forced into a trial in front of a shrunken 6-person jury panel. He was convicted and then sentenced to over a year in prison, followed by 5 years of probation. Now, Mr. Keon fought back against this, demanding that his 6th Amendment rights to a full 12-person jury was actually violated. Now, the state appeals court that reviewed his case outright rejected his arguments, pointing to a 1970 Supreme Court precedent in a case called Williams versus Florida. Now, in that older Supreme Court ruling, the Supreme Court used what is known as kind of a cost-benefit analysis, claiming that a shrunken 6-person jury could be equally effective as a traditional one. But Mr. Keon's legal team just brought this issue straight to the Supreme Court, arguing that the era of watering down the Bill of Rights is now officially over. They argue that the Supreme Court's recent precedent has changed, and essentially has changed since that prior Supreme Court ruling. And now that this rule that they've been using and that was used by lower courts is essentially overruled in some ways, and they need to overrule his prior decision. Now, the big question is, why did the Supreme Court suddenly grant review to this case and this issue? Well, that is because Mr. Keon's petition completely cornered the Supreme Court using their own modern logic and some new rulings that came from the Supreme Court. In his petition for review, Mr. Keon pointed directly to a massive landmark victory from a 2020 case called Ramos versus Louisiana. Now, in that case, the Supreme Court completely struck down non-unanimous jury verdicts, ruling that the 6th Amendment must be interpreted exactly as it was understood when the Bill of Rights was adopted in 1791. So they kind of went back to an originalist review and theory and analysis when it comes to the 6th Amendment as well. We've seen them do a very similar thing when it comes to the 2nd Amendment. The court in Ramos explicitly rejected the exact kind of cost-benefit analysis that was used in that 1970s prior case by the Supreme Court, stating that it is not the job of judges to decide which historic features of a jury trial are important enough to keep and which ones they can actually discard. Mr. Keon's arguments go back to the originalist concepts and focus on the intent of the actual founders. He argues that at the founding of this country, the word jury meant one thing and one thing only: 12 ordinary individuals who served on that jury. When the people enshrined that right, they did not attach a rider or exception to the rule, allowing future governments or state bureaucrats to downsize that right to simply save time or money. Now, to show how confident Mr. Keon's legal team was in this kind of originalist argument, they filed for a motion asking the Supreme Court to completely dispense of their requirement of a joint appendix. They told the justices there that this is a pure question of law, meaning that the facts of the local arrest do not matter at all, and the lower court's opinion was completely unreasoned, and there is zero actual need to waste time or money compiling a massive mountain of lower court records. In fact, the state of Florida actually agreed, and they did not even oppose that request. By dropping this filing, Keon is kind of stripping away the administrative noise and forcing the Supreme Court to look strictly at one thing and one thing only. Does the Constitution mean what it says when it guarantees a jury trial? Now, this is where this case applies to all Americans, especially, viewers of mine, all of us were gun owners, and this is something that we need to watch out for. So think about this. If the government is allowed to prosecute complex, high-stakes Second Amendment cases or technical compliance violations against the NFA or the ATF going against you, and they can do that in front of a shrunken 6-person jury, it becomes drastically easier to secure a conviction. It takes far less effort for a state or an agency to manipulate or pressure 6 people than it does to convince or to actually get a ruling from a 12-person jury. Also, this impacts your fundamental rights as an American by watering down what type of protections the founders actually intended when they enshrined the 6th Amendment. But now all of this is currently coming to a head in front of the Supreme Court, and it's going to happen before the end of this year. The Supreme Court just issued a new order for the opening briefs to be submitted to them just next week on August 6th. This will open up the case for briefs and oppositions, and all of that will start. So all the paper, filings in the battle of the papers will really start, starting next month. And then we will likely see a flood of amicus briefs that are filed in favor of both sides. But also in the docket, we now know that both parties are actually targeting and have agreed that they want the Supreme Court to hold oral arguments in this case in December. That means by the end of this year, another major constitutional rights challenge will be argued in front of the Supreme Court. That also potentially sets this case up to be decided very quickly in front of the Supreme Court and potentially even early next year. So the Supreme Court appears to be moving very fast in this case. Again, this is an interesting case that was taken up by the Supreme Court. This was an issue and a challenge that had been kind of percolating for a while in the lower courts. You've had states have this law in place. People have been pointing it out as an issue. And now the Supreme Court appears to be stepping in on the question of jury trials. And the question will be, will they also go back to the originalist concepts when it comes to this 12-person jury issue? So make no mistake, by granting review, the Supreme Court's conservative majority has signaled potentially a massive change on this critical constitutional right. They are poised to declare potentially that states cannot alter, shrink, or dilute the literal text of the Bill of Rights under the guise of administrative convenience or potential cost savings. So that is the critical case that the Supreme Court just granted review in, and that they're going to hear arguments in before the end of this year. That loophole is officially challenged. It will be decided by the Supreme Court, and really, you can tell by some of these filings by the government that they're freaking out about what potentially could happen with this ruling. So I'll be tracking this case as it moves towards oral arguments potentially in December. As we get more information, I will let you guys know. But if you want to stay ahead and get updates on this case and other issues going forward, make sure you subscribe to the channel and also turn on all notifications to ensure you never miss these videos when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.